Good afternoon. This is Marc Wheat. I am General Counsel for Advancing American Freedom. And this afternoon, we're going to be discussing what the Supreme Court heard oral arguments on yesterday. This was in two cases challenging many of President Trump's tariffs, decisions that will shape not only U.S. trade policy, economic freedom, but constitutional law for decades. This may be one of the most significant constitutional challenges in the last 50 years, particularly relating to balance of powers among the legislative, executive, and judicial branches. This afternoon, we're joined by Jeffrey Schwab, who is representing V.O.S. selections and other small businesses in litigation yesterday at the Supreme Court. Economic historian Phil Magness from the Independent Institute, and our own Timothy Harper from our legal team here at Advancing American Freedom Foundation. They will walk us through what happened in oral arguments yesterday and explain the legal, economic, and constitutional implications. At Advancing American Freedom, we advocate for the principles that underpin free trade, economic liberty, and constitutional limits of government intervention. And these two cases that were argued yesterday wrap all of those up. AAF has been consistently urging an end to tariffs this year and other policies that would undermine a pro-growth agenda that was so successful during President Trump's first term. So let me ask to Jeffrey Schwab, if you could take yourself off mute. I'm going to ask your first question. Could you walk us through the legal challenges at the core of these cases, highlighting the statutory interpretation of IEEPA, the major questions doctrine, and the non-delegation doctrine?
Sure. Yeah. So as indicated by Mark, there are several arguments in this case. The underlying theory is that Congress, under the Constitution, is given the power to tariff. It can delegate that power, but it has to do so explicitly and has to do so in a way that provides some limits. It can't just give the farm away. And so the first question is whether the statute that the president relies on, IEEPA, the International Emergency Economic Powers Act, actually gives the president the power to impose tariffs. And in fact, no president before has ever used IEEPA to impose tariffs. So it's a novel question. And yesterday at the Supreme Court, the justices asked many questions about the proper interpretation of IEEPA. The statute provides for a number of powers, including regulate importation. And the question before the court on that case was whether regulate importation means impose tariffs or duties. And of course, we say that it does not, and the government says that it does. So that's the first argument, and we think we should win on that. If we win on that, it's a pretty easy case. IEEPA doesn't authorize tariffs, so the president's tariffs are not authorized and therefore illegal, and they should go away. But we have several other arguments. One of the things that is relevant is the major questions doctrine when interpreting the statutory powers given by Congress to the executive branch. And under the major questions doctrine, which had been used against the Biden administration, in particular the Biden administration's loan forgiveness program, the Supreme Court says that when there's a major question of political or economic consequence, then Congress needs to be explicit about what delegation it's making. And here, obviously, we have a major question. It is the tariffs that, according to the administration, could result in $4 trillion of revenue being raised by the government over the next 10 years. If I think, as we said, either in our brief or at some point at oral argument, if this isn't a major question, nothing is. And so therefore, the argument is that Congress needs to speak clearly. what's interesting about the major
So
questions.
let me underline that, like, for a big picture. How much revenue is the Treasury Department identifying that they think that they can extract from American consumers and taxpayers just through the tariffs over the next 10 years?
Yeah, I think their own estimate. Maybe Phil can speak
Yeah.
more clearly on this, but I think it was up to somewhere between $2 and $4 trillion.
Right. And when you think about, $4 trillion compared with all of the effort trying to get Congress just to pass reconciliation, just so that we wouldn't have a snapback on old tax policy, keep these tax cuts permanent. All of this stuff that may be illegal being pushed by the Trump administration is washing away a lot of the benefit of those tax cuts. It's incredible. It's incredible. So when we focus in on legal interpretation doctrines like the non-delegation doctrine, the major questions doctrine, this is real money when we're faced with the fact that it is super hard to get any productive work out of Congress, that they're really derogating their powers under the Constitution. This is the only game in town where we have to go to the courts to have our voices heard on how the laws should be applied.
Yeah, I mean, again, if anything is a question of major economic consequence, it's this case. And just to continue some of the arguments, so major question, it kind of does fit into the interpretation of IEEPA, but we also have sort of what we call backup arguments. One is if IEEPA does have some limits, it requires the president to declare an emergency. It requires there be a unusual and extraordinary threat that comes from somewhere outside of the United States. The president says that the trade deficit is an emergency and creates an unusual and extraordinary threat. But in his own executive order, he calls the trade deficit persistent, which seems the opposite of an unusual and extraordinary emergency. So one of our backup arguments is even if IEEPA allows some tariffs, it doesn't allow these tariffs because it's not an emergency, it's not unusual, it's not extraordinary, and the power that the president is claiming to tariff is so broad, it would effectively give the president unlimited authority to tariff. And that leads into our last argument, and that is the non-delegation doctrine, because the non-delegation doctrine, which has kind of been out there, but isn't really usually enforced. But basically, what it says is Congress just can't delegate its entire authority that it has under the Constitution to another branch of government with like no oversight, or just give the farm away. And here, if the president's interpretation is right, the Congress has effectively given the president the power to impose tariffs with no limits. In particular, because going back to the unusual, extraordinary, and emergency, the president says that all of those things are not reviewable by courts, that they cannot second guess the president when it comes to whether something's an emergency or whether something is an unusual and extraordinary threat. So that would mean there'd be no oversight. And so non-delegation doctrine would say, well, that's too much of a delegation. We can't do that. And that leads into the last argument, which is constitutional avoidance. And that basically says when interpreting a statute, if the interpretation that you come to would be unconstitutional, then the court should find some other way to interpret it. And so their non-delegation kind of comes into play, saying, right, well, if the president's right, then that would be unconstitutional. So that the president can't be right. You've got to find another way to incorporate it. So those are our 6 or 7 different arguments. And the nice thing is that if the court accepts one of them, we should win. The bad thing, I guess, is that if the justices don't agree, we could have an opinion where some justices think that we win for some reason, and some other justices think we win for a different reason, which would be a little less ideal, but better than not winning.
Well, I'm so grateful that you brought this lawsuit on behalf of so many Americans who are just frustrated that our voices can't be heard by a non-functioning Congress, and the only way that we can get justice is to go to one of the other branches. And here we are. We're waiting for the Supreme Court to decide. And Phil Magness, I am really grateful for your friendship with Advancing American Freedom, because you are one of maybe a half dozen PhDs in the country who have done their scholarly work focusing on the history of tariffs in the United States. And you know, one of our arguments, we were talking with lots of congressional staff this morning at a breakfast that we held for them to go over these oral arguments. And one of the things that we posed to them was, if this were real law, why is it impossible for people in the import-export business to plan for their business when the law changes every day? We have just all kinds of whimsical applications of these laws. One of the things that was astonishing, and one of the issues I posed to congressional staff, were, if this were up to Congress, would they have imposed tariffs on Israel and Switzerland? This is supposed to be for protection of national security. I can't imagine any nation states that are closer to our interests in having a peaceable global tariff structure that would promote free trade. So let me just throw that question to you. Well, how did you see the arguments go yesterday, and what are the implications from a policy perspective?
Yeah. Well, I thought the arguments went well for the challengers of Trump's tariffs. And the interesting historical angle here is quite a bit of attention was paid to who has the tax power and the question, even if tariffs are taxes. The administration took this line that tariffs are actually a regulatory power and not a tax. Still trying to reconcile that with the fact that Trump seems to be tweeting out daily about the trillions of dollars in revenue that's coming in. As Jeff alluded to, their own filings from the Council of Economic Advisors say 2.8 trillion to $4 trillion in tax revenue are going to be raised by these tariffs. But the historical implication is, if they are taxes, they're situated very clearly under a power that's essentially exclusively Congress's. And this goes back to the founding. The idea is that the law should be set by your own representatives, the people that are representing their constituents and their interests in Congress. And that is its own body. It's not a subordinate body to the president. It's not doesn't belong to any other branch. Congress sets the agenda there in and of itself. And the idea here is you give stability in the predictability of tax rates over time. Congress codifies things, or if they cede any of that power to the president, which there have been some statutes basically since the 1920s to the present day, where Congress has allowed the executive to modify rates or to put in temporary tariffs, but they have to meet all these requirements of the statute that involves a legislative oversight hearing, study periods. A lot of them are limited to only a fixed number of days. But all of this is designed to give predictability to the economic environment. You take predictability away, and you get a president that's changing the rate on Tuesday that he imposed on the previous Thursday, which we've seen over the last several months. Think of yourself as a business owner. What are you doing in that type of a situation? You don't know if it's time to place your orders for next month or next year. You don't know if it's appropriate to source from inside the United States or outside of the United States, because your prices for all your inputs could be completely different based on the whim of the president waking up and deciding, hey, he doesn't like a TV advertisement that's being run by Canada, or he's mad at a judge down in Brazil, or he had a bad meeting with the prime minister of Japan and just decided to overnight change the tariff rates. So that uncertainty wreaks economic havoc in its own right. And we've seen this in the way that markets have responded to Trump's kind of erratic unilateral executive declarations. And this is all a feature of the fact that he's moved outside of law and legislation and moved into executive orders as the main mechanism. And everything we saw yesterday, the justices were asked some very pointed questions about this, including the administration's claim that a tariff is not a tax, especially because the tax is assessed internally on Americans. We bear the burden of that, so our economic consequences are profound and extensive. And the court just didn't seem to be buying the administration's argument there.
Right. Yeah. Before I turn to Timothy Harper, my colleague here at Advancing American Freedom, let me call to the attention to the audience if they would like to pose some questions of their own. Just go to the chat box at the bottom, post them, and I will consolidate them and ask our panel questions. One of the things that I was on WLS radio in Chicago the other day talking about these tariffs. And one of the hosts said that it is so hard for businesses to make decisions based on these whimsical applications of tariffs that change daily. How can anybody function? And my response was, you just posed a very common sense observation that if you cannot rely on a law being stable for planning, it's probably not law you're dealing with. And this is something that we are deeply troubled by at Advancing American Freedom. And I want to ask Timothy Harper a question on this, because once Congress delegates power to the administration, if the Supreme Court does not find it to be unconstitutional, and if Congress tries to take it back, it is almost impossible to take this power back. And we were really gratified when Mountain States Legal pinged us during the oral arguments saying, hey, these questions by Justices Gorsuch and Barrett look like they're taking some elements from the AAF brief on ratchet power. So Timothy, I wonder if you wanted to expand on that, and how can we write the constitutional order to bring powers back to Congress through this case? And if it fails, what do we do next?
Right. Well, if the court rules that the tariffs are not within the power of the president, that will at least temporarily settle that issue. But the problem is, if, as you said, if the court rules that the tariffs are legal, and Congress decides, no, actually, we want to take this power back that we have supposedly delegated to the president, it could pass a law, but the president could veto that law. So then Congress would need a supermajority, a two-thirds majority of both chambers of Congress in order to override that veto. And so you have a situation where the sort of constitutional system is turned on its head, where instead of it being very hard for the president to exercise these powers, it's very hard for Congress to exercise the powers that are vested explicitly in it in Article 1 of the Constitution.
Well, it would be one thing to have a victory going forward, but what of those businesses and consumers who have been paying tariffs that we think have been imposed illegally all along? Jeff or Phil, I wonder if you might have comments on this was posed by one of our viewers. What would be the remedies? How would someone be made whole knowing all along that they paid exorbitant taxes on something that was illegitimately imposed?
Well, this is an important question from the economic side because it really brings out where the harm of these tariffs are. Now, the administration was asked in court yesterday who pays the tariff, and they did not do a very good job at answering it. It was kind of this disjointed, all over the place answer. But the reality is the economic incidence of the tariff falls on people in the United States. And the person that's directly on the line to pay for it is the U.S. based importer. It's the company that brings the good in. They're hit with the tariff bill when the goods arrive. Now, what do they do with that tariff bill? They pass on some of the costs. We call this the incidence of it to American consumers. or to people further down their supply chain, or people that are purchasing their raw materials as inputs to build things in the United States. So all of that tax burden gets shared around for basically anyone that's in an economic transaction with the company that tariffed the good. So it becomes a very substantial fee when you're talking tens of billions of dollars, which is what we've collected so far. And the original remedy of this, and this was the point in the first case, is that customs would have to refund that money and refund it right back to the importing firms. Now, there's a problem there because the money is distributed back to the importers. How do you address or remedy that same situation for everyone else further down the chain that has paid a higher price at Walmart or the grocery store because that was passed through onto American consumers? That becomes much trickier, and it comes down to essentially what does the import company decide to do. But this is, again, it highlights why allowing these tariffs to continue to persist, the problem gets worse and worse over time, the more tax revenue that they collect, because when they try to make it whole and actually have to refund it to people, it doesn't all make its way back to the people that actually bared the burden of that in the end.
And there are sort of the unanticipated events, which are never going to get a remedy. Like I can imagine every red county and every red state who have soybean farmers, those soybean farmers may have lost permanent markets because of these tariff strategies, where other importers that we could reliably export to have reconfigured their supply chain, and they're now pulling from Argentina and Brazil.
Exactly. That's the
I,
Smoot-Hawley error was made. It's actually one of the major harms of the tariff is the fact that other countries could retaliate against us. We learned this the hard way in 1930 when we put up a tariff on the United States to supposedly insulate us from the Great Depression. And what it did is it triggered all these other countries abroad to impose retaliatory tariffs on the U.S., and it killed off the agriculture sector because that was our main export sector at the time. And we're seeing the exact same thing playing out in the soybean market.
right. So, Phil, while I've got you here, uh, could you respond to the allegation that what made America great was our tariff wall, and
Right.
what were the views of the founders on tariffs, and how did the experience in the American Revolution
Absolutely.
form the attitude of our founders when they were framing the Constitution?
Absolutely. So the first question here, the claim is often made that in the 19th century we had high tariff barriers, and this supposedly spawned the Industrial Revolution. The United States became a wealthy country under that. This is actually, it's empirically not justified. It's not a sound claim. And we know this for a couple of reasons. The first one is the United States in the 19th century, it wasn't uniformly protectionist. It was actually a back and forth kind of a seesaw effect, especially the first half of the century between protection, free trade, protection, and free trade. And it's actually the periods of free trade where you see some of the biggest growth. So between about the 1840s and the start of the Civil War, that's often seen as the jumpstart point for American industrialization. And it's really in the northern states that this takes off. That's why they win the Civil War. But this is also coinciding with a period where we're lowering our tariff rates. And then tariffs do come back after the Civil War. But what we see is if you compare sectors that are protected by tariffs, and this is steel and iron and a lot of goods that have competition abroad, and then compare them with other sectors that are not affected so much by trade. Think of like electrification, transport, certain types of internal transport. Those sectors, it turns out that the non-tariff sectors are growing at a faster rate than the tariff sectors. They're a bigger contributor to American growth in the 19th century. So every empirical analysis that's looked into this in any depth has concluded that this story is just nonsense. It's actually the tariffs were a burden on U.S. economic development. We grew in spite of them, not because of them. Now, moving back to the founding era, there's actually a very strong claim to be made here that free trade was one of the major causes of why we revolted against Great Britain. If you remember the Boston Tea Party, what is it over? It's an import tax on tea. And there are multiple items of this that are passed in the 1760s by the British Parliament abroad, and they give rise to this claim, no taxation without representation. That's the American colonists protesting the restrictions on trade, the tariffs effectively, that Britain had put in on us from abroad. And you see this made explicitly. Thomas Jefferson in 1774 writes this pamphlet that vaults him into fame, where he declares that free trade is the right of all American colonists to engage in free commerce with the world, and this right has been usurped from them without any representation by Parliament. And this gets condensed down into the text of the Declaration of Independence in 1776, where one of their major charges against King George is that he's cut off our trade from the rest of the world. So you find out in the founding era, almost all of the major founders are also subscribers to this doctrine of free trade. Now, there's some exceptions. Alexander Hamilton is often cited as a protectionist, but when it came time to actually make policy, Hamilton, as Secretary of the Treasury, he advises the first government. He's the Washington Secretary of the Treasury. He helps Congress draft the first tariff law, and they do pass a tariff, but it's a relatively low tariff designed to raise revenue, not to protect industry, not to protect American sector from competition abroad. So he jettisons a lot of the protectionist rationales simply to stick to a revenue tariff, because remember, they didn't have the income tax at the time. And this lasts throughout the founding era. It's really not until the 1820s that you start seeing the shift in rhetoric where protectionism becomes a cause unto itself. And again, as I mentioned, it's this seesaw for the rest of the 19th century between high and low tariffs.
So it seems like it's really part of our DNA as a nation to be a low tax, free trade environment where people can all be free to compete. My worry is, what if, in the light of a supine Congress, that the Supreme Court decides this is too heavy of a lift to find these things to be unconstitutional? What if we lose? What happens after this? We're going to keep bringing back more and more challenges on these issues. I think that with the fact that the Chevron deference doctrine for courts to defer to regulatory agencies, that's gone thanks to Loper Bright. We've probably filed about 9 amicus briefs relating to getting rid of the Chevron doctrine. I want to ask Jeff and Timothy, with Chevron doctrine being down, courts are going to be much less deferential to agencies moving along with some kind of tariff agenda. How might we be able to win in the future if we lose on this case? What are the implications, and how can we work to take those powers back from that Congress unwisely delegated to the executive?
You can go ahead if you want, Tim.
I think if we lose on this case, it's going to be difficult because, as we said earlier, Congress would need probably a supermajority, or we need the case overturned. It could be that the court rules very narrowly in favor of the tariffs in a way that keeps the door open for later challenges. But it is encouraging that at least the court will not defer to an administrative agency's interpretation. The question is, will they extend that same critical line to the president, especially in his supposed foreign affairs powers, or will they defer?
Jeff, any other final thoughts?
Yeah, just to follow up on that, I think if we do lose the case, I don't think it will be a wholesale that the president can do whatever he wants. I think where the court could struggle on this is that they might want to say that IEEPA allows some tariffs, but then they have to figure out where to draw the line, because it's very difficult to figure that out. And then they have to decide how much deference they're going to give the president, how much scrutiny courts should have. And that's where maybe the Chevron deference, or the lack of Chevron deference, comes in, and the courts can be a little more questioning of whether a particular tariff is actually justified. So That would not be ideal, but I do not think it's very likely that there are 5 justices on the court that will just give the president wholesale unilateral authority under IEEPA to do what he's doing now and whatever he wants. So it just gets a lot more complicated whenever you get into IEEPA allows some tariffs, but not all.
Right. Well, gentlemen, we're at our closing here. I want to thank each of you for your contributions to safeguarding our constitutional order and keeping our republic safe for the next generation. Here at Advancing American Freedom Foundation, we're committed to defending constitutional principles and pro-growth policies. And we appreciate each of you for what you do to keep those principles shining bright. And for those of you in the audience, we hope you can join us for our next webinar and continue to partner with us for these important policy battles. Thank you very much.